Picture this. You're navigating heavy traffic in the Treasure Valley, maybe heading to a job site, and bam, you're in a fender bender. Or, hey, maybe you're a freelancer staring at a stack of unpaid invoices from a client who just flat out refuses to pay. It's incredibly frustrating, right? And the thought of hiring some expensive lawyer to fix it? Honestly, that can be just as daunting. But what if you could take control and actually get justice on your own? Well, welcome to this explainer. Today we're going to walk through an empowering, step-by-step roadmap to navigating Idaho's small claims court system. We're going to demystify the whole process so you can hold people accountable, affordably, and completely without an attorney.
Now take a look at this number, $15,000. For nearly 2 decades, Idaho's small claims limit was capped at a really modest $5,000, which was actually one of the lowest in the western U.S. But thanks to a massive legislative change under Senate Bill 1330 taking effect on July 1, 2026, that limit literally triples to $15,000. This is a total game changer. It means everyday Idahoans and small businesses finally have a practical way to resolve mid-sized commercial, contractual, or property disputes without taking on the crushing financial burden of formal civil litigation. So here is our playbook for today. 1. Is small claims for you? 2. Pre-filing preparation. 3. Filing and serving. 4. Pre-trial and court day. 5. After the verdict. And 6. Conclusion and legal disclaimer. Let's get right into it.
Section 1. Is small claims for you? Understanding the limits.
First things first, what exactly is it? Well, Idaho Small Claims Court is a specialized, informal forum within the Magistrate Division. Its whole purpose is to resolve lower-value civil disputes quickly and inexpensively. The absolute most important thing to know here, it operates entirely without attorneys or juries. This is an entry-level court designed to level the playing field for everyday folks and small businesses trying to recover money or personal property.
But you've got to know that the court's power is strictly limited. Let's look at property damage versus personal injury. Say you're in a work truck collision near Boise. The at-fault driver wrecks your truck and ruins the tools in the back. That is clear-cut property damage. Your repair estimates and tool receipts, that's exactly what small claims is built for. But what if you also suffered severe neck pain that gets worse over a few weeks, causing you to miss work and need physical therapy? Taking that to small claims is actually pretty risky. Why? Because the small claims department is strictly prohibited from awarding damages for pain and suffering. If you file too early for too little, you might box yourself into a low payout that doesn't even come close to covering your long-term medical costs.
Section 2. Pre-filing preparation. Getting your ducks in a row. Okay, the very first thing you need to check is the clock. Idaho has strict statutes of limitations. You have exactly 2 years for personal injury, 3 years for property damage, 4 years for oral contracts, and 5 years if it's a written contract. Listen, missing these deadlines will permanently bar your claim no matter how rock-solid your evidence is. And never just assume one deadline applies to everything, because property and injury run on completely different clocks.
Now, here's a great insider tip from our sources on how to lay the groundwork early. Send a pre-suit demand letter via certified mail about 30 days before you actually file. Also, and this is absolutely crucial, make sure you identify the exact proper defendant. In an auto collision, for example, a lot of people mistakenly try to sue the insurance company. You can't do that. You have to name the at-fault driver or the business that owns the vehicle. Getting that wrong can seriously delay or even totally derail your case.
Section 3. Filing and serving. Navigating the bureaucracy.
So, how do you actually file? It breaks down into 4 essential steps. First, figure out the right venue, usually the county where the defendant lives or where the incident happened, and fill out the standard claim form, which is CAO SC12. Second, you submit it and pay the civil filing fee of $69. But hey, if you can't afford that, you aren't locked out of the justice system. Indigent filers can submit Form CAO FW19 to ask for a fee waiver based on their income. Third, you serve the defendant. And fourth, you file an affidavit of service with the court.
And you know what? You might not even have to drive down to the courthouse to do this. The iCourt Guide and File System is a fantastic online tool that literally walks self-represented litigants through preparing and e-filing all these exact forms.
Now about step 3, serving the defendant. You can't just text them and say, "Hey, see you in court." You have to legally deliver the paperwork. In Idaho, you generally get 30 days from filing to serve them. You can do this through certified mail with the return receipt,
which runs about $10. Or you can hire the county sheriff, use a private process server, or just have an uninvolved adult hand deliver it. Your case literally cannot move forward until they are properly notified and you've filed that affidavit of service to prove it.
Section 4. Pre-trial and court day. Facing the judge. Just a quick note here, once served, the defendant has exactly 21 calendar days to file a written answer.
Okay, listen to this rule from Idaho Code Section 1-2308. Small claims actions do not use juries or attorneys. The attorney cannot appear with you in court. How empowering is that? It means you, an everyday citizen, and a massive corporation face off on a perfectly even playing field. Nobody can outspend you on legal fees in that courtroom. It's just you, the defendant, and the judge.
But before you even see that judge, be ready for mediation. Some Idaho counties actually have mandatory mediation programs. That means you might sit down with a neutral third party, like someone from AAA Mediation Services, to try and reach an early collaborative agreement. Mediation is confidential, it's way less aggressive, and it often resolves the dispute a lot faster than arguing in front of a judge.
If mediation doesn't pan out, it is trial time. Here is your courtroom playbook. Dress professionally. It shows respect for the process. When you speak, talk directly to the magistrate judge, not the defendant. Stick purely to the facts. I know it's hard, but leave the emotion at the door, because the judge only cares about the evidence. And here's a massive insider tip for you. Bring 3 physical copies of all your exhibits, one for the judge, one for the defendant, and one for you. Whether it's repair estimates, text messages, or receipts, being organized is what wins cases.
Section 5. After the verdict. Securing your victory.
Okay, so you won. Now what? Well, this is where a pretty stark reality of the legal system kicks in. The court gives you a piece of paper saying you're owed money, but the court does not go out and collect that money for you. The burden of actually enforcing that judgment falls entirely on your shoulders.
If the losing side just refuses to write you a check, you do have legal collection tools, but you have to initiate them. You can seek wage garnishments to take money directly from their paycheck, you can request bank levies, or even place property liens through the county recorder. But also keep in mind, the fight might not be over right away. The losing side has a 30-day window to file a notice of appeal to the district court. That costs an $81 fee and triggers a completely new trial where attorneys actually are allowed. So maybe don't pop the champagne until that 30-day window officially closes.
Section 6. Conclusion and legal disclaimer. Empowering your next steps.
So what's our main takeaway here? Thorough preparation and strict adherence to deadlines really do give you the power to seek justice affordably. You don't need a law degree to advocate for yourself. By understanding those statutes of limitations, using tools like iCourt Guide and File, showing up with organized evidence, and knowing the limits of the system, you are now totally armed with the insider knowledge you need to navigate Idaho's small claims courts with confidence.
Now, before we wrap up, please review this essential disclaimer. This explainer provides informative guidance on filing a small claims case based on publicly available legal frameworks. It does not constitute legal advice. Court limits and procedures can and do change, and if you're facing serious injuries, complex coverage issues, or highly disputed fault, you should absolutely always consult a legal professional for your specific concerns.
I'm going to leave you with this final thought. With the Idaho small claims limit jumping all the way to $15,000 in 2026, what unsettled dispute, unpaid invoice, or property damage have you been sitting on that you might finally have the power to resolve? The tools are there, the playing field is completely level, and now you know the playbook. Thanks so much for joining me on this explainer.